So we're going to talk now about prosecutor-driven criminal justice reform. We've gathered a group of stellar researchers who are working with the Philadelphia DA's office, and they're going to talk about lessons learned in various aspects of reform that the Philly DA's office is interested in pursuing, but not just pursuing, also measuring and understanding. And so to introduce the panel, it's my pleasure to ask Penn Professor of Criminology Aurelie Ouss to come join us, one of our affiliated faculty members and a real bright light in the academy today. So thanks very much.
Great. Thank you so much for having us here today. So my name is Aurelie Ouss, and I have been leading with Greg Widgway, also in the criminology department, a team of researchers who has been embedded within the Philadelphia District Attorney's Office starting in the spring of 2020. And so we have been lucky enough to partner with both prosecutors in the DA's office, but also the Data Lab, who is a group of data analysts who work to understand different aspects of criminal justice within Philadelphia. And so as part of this effort, our team has been lucky to be able to ask important research questions to understand both what prosecutors do on a day-to-day level, so bring to academics an understanding of the proverbial black box of what you all do on a day-to-day basis, and also understand how different dimensions of criminal justice reform, which in particular was led by current Philadelphia District Attorney Larry Krasner's office, how these different policy efforts have influenced both fairness and equity and public safety within Philadelphia. Today we're going to hear about various of the research projects that our team has been leading since starting this effort. So this is going to be very, very quick overviews. We're going to have 5 presentations, each of which are going to be under 10 minutes. And we're going to leave plenty of time for Q&A to hear about any of the dimensions you're interested in learning more about. So are going to be index cards over here if you want to write down your questions. We'll have all the questions at the end. You can pass them over and we'll have time to answer questions that you have about the work that we've been doing. I do want to thank Arnold Ventures, who has been funding this research effort. I also want to thank all of the prosecutors who have kindly been answering our questions, so that we make sure that as we conduct, our mostly quantitative research, we are able to understand as best as possible what is going on, what your jobs look like, and what the policies that you're implementing, how they are translating into your day-to-day practices. I also want to thank the Data Lab, who have been helping us understand the many sources of data that we have been using. So these data includes things like court records, like paper files that you all keep describing the cases that you're working on. And since our team are also employees of the DA's office, they have been able to spend some time shadowing different prosecutors. And these prosecutors have been answering questions about what their day-to-day looks like. So we spend the 2 first years of this endeavor really trying to understand both what the day-to-day and policies look like, and also understand how we could use different data sets to answer important policy and practice questions. And so I'm going to hand it over to my colleagues who will tell you about what what the 3rd year of work has led us to, which is concrete research questions about different projects. So first we'll hear from Lindsey Graef, who will tell us about systemic failures to appear in court. Then we'll hear from Viet Nguyen, who will tell us about different policies implemented by the DA's office to reduce the scale of supervision and incarceration. Then we'll hear from Lee Ozier, who will tell us about how different prosecutor-driven criminal justice reform efforts have influenced racial disparities. We'll hear about from Francesca Arruda de Amaral about gun policies in particular, and prosecutor-driven reform and gun policies. And then we'll finish up with Julia Reinhold, who will tell us about plea bargaining. So we will start off with Lindsey, who will tell us about systemic failures to appear in court. Thank you.
Where are the slides? They're on the desktop. Nope, that's not going to work. Okay, we'll go without presenter view. Okay, so I'm going to start by talking about something that anyone who has spent any time in the criminal courts is probably all too familiar with, and that is people don't show up for court. And this is a project that I'm working on with several co-authors, including Aurelie, Sandy Mason, who's here in the law school, and also Megan Stevenson. So pretrial policy historically has pretty much exclusively focused on defendants' failure to appear. But we have many institutions and tools that are really focused on getting defendants to show up. So we make defendants often pay cash bail in order to supposedly ensure their appearance. We might keep them in jail pre-trial if they can't put up that collateral. Many jurisdictions now have entire pretrial supervision agencies that are focused on monitoring defendants. And we have this large industry of bail bondsmen who even serve as headhunters if defendants fail to appear. Oh, my slides are not staying up. Okay. And the rationale for all of this is that courts can't work and justice can't be served if defendants don't show up to court. But the courts also can't work if other people don't show up. So we need judges and juries, we need defense attorneys and prosecutors, we need victims, we need police officers and other witnesses all to show up and participate in this court process. But the criminal justice literature so far is missing really basic facts about court appearance by these other actors. So in this paper, we're asking how common are failures to appear by these other actors? And what happens to cases when one of these other people doesn't show up for court? So our main data source for this project is docket entries that are entered by the clerks of court at each hearing. And so this is basically just a large text field where they write a summary of what happened that day in court. And we can identify failures to appear by different actors by searching for keywords in this field. So as you can see in this example, the clerk might write something like police officer unavailable. We can catch those keywords and we can flag this as an officer failure to appear. Our main sample is cases that are not diverted between January 2010 and just before the pandemic. And we have to drop diverted cases because these cases are much more likely to be expunged. And when a case is expunged, we no longer have this detailed docket entry text for the case, and so we can't see failures to appear for those cases. We also use some data on who's associated with the case. So we have information on, for example, the subpoenas that prosecutors send to police officers to know when officers are supposed to show up for cases and hearings. So we start by just describing the prevalence of failures to appear by non-defendants. And overall, we see that about 53% of cases will have at least one failure to appear by a police officer, a witness, or a victim at some point in the case. We can also break this out by actor, and we see that almost all types of actors, so officers, victims, and other types of witnesses, they all fail to appear at a rate that's about equal or more often than defendants. And even private defense attorneys who are paid sometimes lots of money to show up in court and defend their client, they're also failing to appear at pretty high rates. But of course, some cases are just more likely to need certain types of people to show up. And so it might be the case that these figures that I just showed you are sort of artificially low because not every case actually has a victim associated to show up. So we might think that denominator is just a little too big. So for example, in this plot, we can see that victims are much more likely to be needed to appear in cases like domestic violence and property cases, but they're much less likely to be needed for drug or DUI cases. So what we can do is we can look at information in the district attorney's case management system. And here we can see when there is a certain actor associated with the case. And so we say if there's a victim associated with the case, for example, we expect that that victim was probably needed to appear at least once throughout the course of the case. And we corroborate this through a lot of conversations with prosecutors and shadowing in court to confirm that this is in fact what's happening. So now we can kind of recalculate those FTA rates, looking at the cases where we know that that person was expected to appear. And when we do this, we see that all types of actors are failing to appear at really high rates and more so than defendants. And then for police officers, we have some more information. So we have information on the subpoenas that prosecutors send for each hearing. And so this means that we can look not only at the cases that officers are supposed to appear for, but the very specific hearings where we know they were supposed to show up. So for officers, we can calculate this hearing level FTA rate. And we find that for hearings where officers are supposed to be in court, they're failing to appear about 13% of the time. And this is actually twice the hearing level rate of defendant FTA. So what happens when someone fails to appear in court? Just descriptively, we see that when an officer, victim, or other type of witness fails to appear, the case is about twice as likely to be dismissed or withdrawn. And we're using dismissal as shorthand, but this bucket is including cases that are dismissed by a judge as well as cases that are withdrawn by a prosecutor. So this top bar here is showing us cases where there was at least one failure to appear by any non-defendant. And the darkest portion of the green there is showing us these cases are dropped well over 50% of the time. We also estimate the effect of FTAs on case outcomes by running a regression of case dismissal on FTAs. And we control for a bunch of things like the defendant's criminal record, the very specific charge of the case, defendant demographics like their age and so on. And so the idea is just that we want to compare cases that are as close as possible on a whole bunch of important variables. And then we just want to see the difference when the main big thing that's changing is whether or not one of these people showed up. And so what this plot is telling us is in the lightest green bar on the left for you all, in cases where everyone shows up, that case is dismissed or withdrawn about 25% of the time. When a police officer fails to appear, the case is about 15 percentage points more likely to be dismissed. And when a victim fails to appear, so this tallest bar, the case is over twice as likely to be dismissed or withdrawn. And in fact, we can look at how much different variables are contributing to this model. And we find that non-defendant failures to appear are actually the most important predictive factor for whether a case is dismissed or withdrawn, more so than the specific charge or any other factor of the case that we're accounting for here. So these FTAs raise a lot of questions for us and also have a lot of potential implications for criminal justice reform. So first, these systemic FTAs really highlight the importance of addressing logistical barriers to court appearance that might be the same for all types of actors. There's been more attention to the fact that, defendants, in order to show up to court, they have to take time off work. They might have to arrange transportation and childcare. This is also true for victims and civilian witnesses, and even to some extent for police officers. Second, we think that the systemic FTAs really call into question the grounds for defendant pretrial policies. So as I highlighted in the beginning, we have really asymmetric ways of ensuring that defendants show up in court. But really, all of these actors share some duty to appear in court. And finally, witness FTA is serving a really important regulatory function in the criminal legal process. Of course, the reasons that people don't show up, they might be really complicated and difficult in some cases. And there are surely lots of these cases where we as a society are losing something really important when someone doesn't show up to testify and the case is dropped. But at the same time, there may be other cases where these FTAs are telling us that this case maybe didn't belong in the criminal justice system in the first place. And so are there cases where the fact that so many actors are opting out of this process indicates that this case might be better served through some alternative process? And those are really difficult questions that we unfortunately don't have the answers to, but we're really hoping that future work by both practitioners and researchers can really grapple with this and start to pull apart some of these things. Thank you.
Great, thank you. So this was an example. Yeah.
So when you came in, there were index cards at registration, and there will be others in the room. If you have questions for the panel, you can write questions on them and pass them down to the front. We'll collect them, and then Aurelie can moderate that if we have time for Q&A at the end. Thanks. Sorry.
Thank you. Thanks for the reminder. So this was an example of descriptive work that our team has been doing. We're really, for a lot of the practitioners in the room, the fact that, non-defendants don't show up to court a lot is something that and we're trying to just describe and give you some information about the scale of the issue, and then open policy conversations about this. Now we're going to tell you about 3 related projects where we're shifting gears and doing something slightly different, which is trying to understand how prosecutor-driven reforms have influenced different dimensions of the criminal justice. So here, practices within the courtroom, then racial disparities, and finally, gun policy. So Viet is going to tell us about prosecutor policies and how courtrooms function.
Thanks, Aurelie, for the introduction. Yeah, so today we're going to present a paper titled Prosecutor Policies and Court Workgroups, Internal Guidelines and Discretion. And so, so one way for head prosecutors to shape outcomes is through use of internal guidelines. And internal guidelines are essentially, a set of, policies or kind of rules communicated to line prosecutors that can be used to control the flow of cases, what cases accept, what cases declined, to set parameters on plea offers in the negotiation process. So this can include, rules against excessive charge bargaining, or rules against, too much kind of different, maybe too many kind of coercive plea offers or whatnot, as well as different rules for influencing sentencing outcomes. But at the same time, we know that line prosecutors still retain individual discretion, and other courtroom actors can adapt to these internal guidelines in different ways. And so these two factors can either, push against the goals of these intended guidelines or internal guidelines, or kind of amplify the goals of these internal guidelines. So with this paper, we kind of want to answer 2 main research questions. What is the effect of internal guidelines on sentencing outcomes? And how do different designs impact courtroom work groups and how cases are resolved? And so to do that, we're going to focus on 2 internal guidelines that were adopted by the Philadelphia DA's office. So the first memo, which we call a general memo, was adopted in February 2018. And it asked line prosecutors to make plea offers targeting the mitigated guidelines of this mitigated range of the sentencing guidelines, as well as to request shorter probation sentences and to consider the costs of excessive punishment. The second memo elaborated on the first memo. So it was adopted in February 2019. And so it built on top of the first memo, and it asked line prosecutors to target an office-wide average of 18 months or less of supervision. So you can see with the second memo, the key distinction is there's this concrete target, that's much more specific, as opposed to the first memo where it's kind of this broad guidance to reduce the level of penalties and severity of sentences. Another key feature of the second memo was it asked the line prosecutors to apply sorry, my screen shut off. Okay, it asked the line prosecutors to apply the sentencing rules to all cases, even if they were disposed at trial. So if you took your case to trial or you resolved your case via an open plea, and in Philadelphia, an open plea is where the defendant pleads guilty but the judge makes the final sentencing decision. If you resolve those cases in the kind of a non-negotiated disposition, the line prosecutor would still be required to give sentencing recommendations that follow these other rules. And so that I kind of view this as kind of guards against coercive plea offers. Another kind of important thing about both of these memos is that they were made public on the day they were implemented. So this became open information to the prosecutors, open information to the defense attorneys and judges. And so this is why we want to consider, like, how do these courtroom actors adopt to these policies that became open information? So to get this question, we're going to look at about 45,000 cases, felony cases in Pennsylvania from 2017 to 2020. And we cut off at 2020, right before the pandemic starts. And we're going to use administrative records. And so to get these questions, we're going to compare case outcomes in Philadelphia versus the rest of Pennsylvania before and after the policies were adopted. And we're going to be able to also kind of control for different criminal history and different case attributes that may impact sentencing decisions. So let's start with looking at the sentencing outcomes. So I'm going to just take our time and walk through this figure. So this left-hand panel is looking at the difference in sentencing outcomes or sentence length compared to cases resolved in the pre-period. And so that first column we see on the far left-hand side, it shows that during the first memo period, the supervision length was about 7 months shorter on average compared to cases disposed in the pre-period. And we also see about a 5-month reduction in incarceration length. And so the general memo decreased supervision length quite substantially. And we see on the right-hand side, this is changes in incarceration rates and prison sentence rates. So you'll see that on the third column, incarceration rates didn't change much compared to the pre-period. But what did change is the prison sentence rate changed by about 4 percentage points. So what the general memo was doing was pushing that tail end of sentences just far down enough where that instead of serving time in prison, they would serve time in county jail. And so, in Philadelphia or Pennsylvania, the rule is if any max sentence is over 2 years, you have to be required to serve it in prison. So they're pushing that time length down just enough so people are serving time in county jail. And so the second memo, if we recall, what it did was it required those concrete sentencing targets, so an office-wide average of 18 months of supervision time for felonies. And we've seen an additional 50% reduction. So it went from a 7-month supervision reduction to 11th month, almost a full year reduction in supervision length, as well as about a 9 to 10th month reduction in incarceration length. And if we look at the sentence type on the right-hand panel, it's a similar pattern. Incarcerations didn't change, but again, we pushed down a lot of the sentences from prison sentences to about now a 6 to 7 percentage point reduction in prison sentence rates. Okay, so both these memos effectively reduce sentence length. And so what we're going to turn to next is looking at how these courtroom actors adapted to these policies. And to do that, we're going to look at the differences in dispositions. So it's a very similar figure, but instead of looking at sentencing outcomes, now we're going to look at different disposition rates. So there are 3 different dispositions that we're looking at. It's the dismissal rate, the negotiated plea rate, and then the non-negotiated plea rate, which are essentially cases that are resolved via an open plea or cases that are resolved at trial. And the trial dispositions are either guilty or acquittal. And so you can see on the first column, there was no change in dismissal rates. It's similar to the pre-period. In the second column, we see a 7 percentage point increase in the number of cases resolved via negotiated plea. And we see a corresponding decrease in those non-negotiated plea. And this isn't surprising, right? If the guidelines, internal guidelines are asking prosecutors to give more lenient offers, we'd expect more cases to be resolved by a negotiated plea. What we find happening during the second memo period is actually much more interesting. So intuitively, if we were to kind of extend that logic to the second memo period, the sentences got even more lenient, right? There are bigger reductions in sentence severity, but we see something different. The negotiated plea rate didn't increase at all. It actually reverted back to the pre-period level. And so we see that, and we also see the slight increase. It's not significant, but a slight increase in non-negotiated pleas. And what we think is happening is that we think legal actors are strategically adapting. And so what we think is happening is our hypothesis is that the defense is strategically adapting to more leniency. And I think this is really critical, and also more transparency. And we find 2 supporting pieces of evidence. The first is that defendants are more willing to take risk with more lenient judges. So what we did was we looked at that change in dispositions for lenient judges versus harsh judges. And when you look at harsh judges, during the first memo period, the negotiated plea rate goes up. Then the second memo period, it stays the same, right? And this makes sense, right? If you're a defendant and you're going to put your sentencing decision in the hand of a judge, you're probably not going to do it, and the judge is more likely to throw the hammer down at you. And when we look at lenient judges, we see that really strong pattern, right? The negotiated plea rates goes up during the first memo period, and they reverts back to the plea period levels during the second memo period. And both defendants across each of these judge types, they're consecutively receiving shorter sentences across the first and second memo. The second piece of evidence we find that supports this hypothesis is that defendants are receiving more favorable outcomes if they resolve their cases with a non-negotiated plea. And if you're not going to take a negotiated plea, it's only logical if you're going to get a better outcome via an open plea or taking your case to trial. And what this figure shows right here is it's comparing the average incarceration length for a non-negotiated disposition, so that's an open plea or taking a case to trial, versus a negotiated plea in the plea period for each of the three different policy periods. And you can see in the first two columns, if you resolve your case via trial or an open plea, your sentence was on average about 8 to 9 months shorter than a negotiated plea. And we see that benefit, that advantage, almost jumps twofold in the second memo period. So if you resolve your case via a trial case or a open plea, it's about a 15-month reduction in sentence time, in incarceration time. And we see the same thing when we look at prison sentence rate, right? There's about 4 or 5 percentage point reduction if you take a case to a non-negotiated disposition. And in the second memo period, we see about 11 percentage point reduction in prison sentence rate. So again, this kind of indicates that, when there's more information, the defenses are strategically adapting and they're able to secure better outcomes for defendants during the second memo period. And they're able to figure out, okay, when should I, not risk my case, but have my case be handled by a judge versus having it be secured by a prosecutor. So altogether, what we find is, internal prosecutor guidelines can influence sentencing outcomes and courtroom groups. But it's important that they're still going to be constrained by other legal actors. In this case, we both see that judges and defense attorney do kind of constrain how the guidelines are implemented and operating. And the important thing about the design of guidelines is that we see like the transparency really matters, as well as the specific balance that we see that were implemented during the second memo, which is that concrete 18-month target. And what we want to kind of move forward to and look at next is, we want to examine how different type of designs operate and how they can have different impacts. We also want to assess the impact of these different designs on public safety and deterrence.
Great. Thank you, Viet. So next up, Lee Ozier is going to look at both this policy and another prosecutor-driven reform effort to see how this influenced racial disparities within the system.
Let me just move the microphone down. Hi, everyone. So today I'm going to be talking about our project, which focuses on looking on how prosecutor decisions can affect racial disparities in the Philadelphia criminal justice system. So first, a bit of context. Oh, okay. Yeah, okay. Can everyone hear me? Okay, great. So first, a bit of context. So Black defendants are overrepresented within the Philadelphia criminal justice system, as they are in criminal justice systems in a lot of different urban environments. And what you can see is that the racial disparities tend to manifest at virtually every stage in the criminal justice process, from stops and arrests to charging to bail decisions, plea negotiations, sentencing, that kind of thing. Another thing to keep in mind is that racial disparities tend to amplify over time with kind of a cascading effect, with decisions that are made early on in the criminal justice process, like with stops and arrests, affecting decisions that are made further down the line, such as with sentencing. So racial disparities are generally introduced into the system very early on in the criminal justice process with stops and arrests. So one question that we had with this project were whether decisions or choices made by prosecutors can affect mitigate racial disparities that are introduced before prosecutors are ever really involved in the system. So our key question was, can prosecutors actually affect or mitigate racial disparities within the criminal justice process? So to look at this, we examined two main sets of policies. I won't go into too much detail because I think Viet covered it quite well. But the first set of policy, this first policy focused on charging. So essentially reducing charging rates by declining to charge certain offenses. And the second policy focused on reducing sentencing lengths, both in terms of incarceration and supervision, by changing or having new sentence length targets for the ADAs. First, the charging policy. So with the charging policy, we saw that there was no real decrease in terms of like racial disparities. So on this chart, you can see that the x-axis is time and the y-axis are charging rates in terms of non-summary arrests. And then the different colored lines are different racial groups, with the green line being Black, the orange line is white, and the blue line is Latino. And so you can see that at the second vertical line that there's like this really stark steep decline. You can see that decline across all racial groups. So there's no real difference. There's no differential impact on the different racial groups. But if you look at, instead of looking at charging rates, you instead look at absolute numbers, you can see that there was a differential impact. So again, the green lines are Black, with the dotted line being number of arrests as of non-summary offenses, and the solid line being arrests that are subsequently made into docket entries. So you can see that at the second vertical dotted line, when the charging policy is introduced, you can see that there is a decline for all racial groups, but that the decline is sharper and more obvious for the Black racial group.
What are blue and red?
So orange is white and blue is Latino. Mm-hmm. So then the sentencing policy. So for this one, we were focusing on graded felonies. So this wouldn't include policies that would, or this wouldn't include cases that would be covered by the charging policy, because that only focused on misdemeanors. So there shouldn't be any overlap. We shouldn't be looking at cases that would be affected by both sets of policies. So in analyzing the sentencing policy, we did find that there was a decrease in overall sentencing lengths for all racial groups. We didn't really find any differential impact for any racial group. And we also found that for all racial groups, cases were less likely to result in conviction. However, that trend was a lot less pronounced when we're talking about Black defendants. There's a few different reasons why this could be. One possible explanation is that Black defendants, before the introduction of the policy, Black defendants were already more likely to have cases that were likely to result in no conviction. So after the policy was enacted, they didn't receive as much of a benefit as other racial groups. So key policy takeaways. So first of all, one primary concern when people are talking about prosecutor-driven reforms to criminal justice processes is whether or not these changes can have a negative impact on, have negative externalities in terms of like public safety, recidivism, victim rights, that sort of thing. Though the scope of our research didn't necessarily focus on those issues, we didn't notice we didn't notice these changes having any. What am I trying to say? We didn't see these changes have any negative impacts in terms of public safety or recidivism. However, whether or not these changes will be effective at mitigating racial disparities will vary depending on context, depending on jurisdiction, and depending on exactly what cases you're targeting. Another thing to keep in mind is that the criminal justice process is holistic. So every aspect, every step in the chain is affected by every other step. So we can talk about prosecutorial decisions when it comes to charging and sentencing, but these are affected by other steps in the process as well, and they affect other steps in the process as well. I covered up my headline there, but this is a map that shows arrest disparities by census tracts. So you can see that the yellow would be 0, and the purple would be any over, I think, 60%. The dark purple would be over 60%. And then the white areas are just like airports or places where people don't live. So you can see in virtually every census tract, there are racial disparities. In Philadelphia, in some census tracts, there are very, very steep and dramatic racial disparities in terms of arrests. And as I said before, racial disparities tend to be introduced at the point of stops and arrests before prosecutors are involved. So if we're trying to think about, mitigating racial disparities within the criminal justice process, we have to think about how disparities are introduced in terms of stops and arrests and what choices that prosecutors can make further down line. And the third point is that if we're trying to analyze the effectiveness of these policies, both in terms of like looking at racial disparities and also looking at other positive externalities, we have to be very conscious about using effective accountability measures. So for example, if we're looking at charging, if we were just to look at charging rates, it would make it seem like there is no differential impact and that there is no real, it's not helping to reduce racial disparities in terms of charging rates. But if we look at absolute numbers, we can see that these policies are helping. And that's it for me.
Great, thank you. So the two first policy evaluation projects, we're studying intended goals that DA Krasner's office had when they implemented these policies. Now we're going to turn to a third project, which is about firearm case outcomes. And this is a project in which there weren't specific policies around firearm case processing. And yet this has been a question that has received a lot of policy attention. This prosecutor-driven criminal justice reform influenced public safety. So Francesca Arruda de Amaral is going to present research on that important question.
Oh, this is off. Okay. So thank you, Aurelie, for the introduction. This is a paper I've worked on with Greg Ridgway and Charles Loeffler over the criminology department. And as Aurelie previewed, we are looking at the absence of policies, so to speak. And so we're looking more at unintended consequences and not direct policy. And so as a motivation, as you all may know, gun violence has claimed a lot of lives in Philadelphia, and there are also over 1,700 non-fatal shooting victims. And there's a concern in the public and critics that progressive prosecutions is exacerbating the problem. And so we analyze data on all gun arrests, and we're defining gun arrests as a violation of the Uniform Firearms Act. And so this would be gun possession, prohibited people possessing a firearm without a license, and then what we define as gun use cases, which are cases in which the police described the offense as involving a gun or a rifle, which would be robberies or homicides for the most part. And so we have 5 questions, and we're not going to explore all of them in detail due to time constraints, but I will try and go through all of them in the time I do have, and I'm happy to delve deeper into any of them during Q&A. And so our first question is, well, gun cases were not targeted by progressive prosecution, so is there even something to study here? Did the dispositions change? And so we start with a descriptive question, and we do find there's an increase in dismissed and withdrawn cases after progressive prosecution policies begin. And there's a decrease in guilty pleas returning to 2010 levels as well. And there's an increase in open cases. To clarify, to ensure this was comparable, we're looking at what the status of a case is 1 year after arrest. Our x-axis is the arrest quarter, and then we're looking at the percent of gun arrests that falls into each bucket. We chose to do this because the courts closed in 2020, and if we were to look any further out, or to consider the final disposition of a case, we would overstate the number of open cases and dismissed cases since they process faster over time. So this was to ensure comparability. And so we do find there is a change. And so our next question was, okay, so the first policy that was very specific was to decline prostitution and marijuana offenses, as well as charge retail theft as non-summary. So, well, did the rate of charging gun cases change? So again, as shown by Lee, we do see that there's a sharp change in the charging of retail theft as non-summary, as well as a sharp change in the charging of drug possession and prostitution. And you see a spike there in terms of rates. And this is just because if I were to show you the numbers, there are very few cases, as in like 10 people or quarter. And so these would be very serious cases, and thus that's why they would be charged. And there's no change in charging gun offenses. So it stayed stable. It wasn't a charging situation. And so we go into our next question, which is about, well, did shifting priorities from low-level cases free up resources to perhaps increase the speed of processing gun arrests? As we all know, there is some discussion on the benefit of having shorter time to disposition and how the process taking too long can be a punishment in and of itself. So, well, are there more resources? Is it going faster? And so here we're looking at the rate of gun case time adjudication for gun cases and non-gun cases to ensure that it's comparable or restricting to felony cases in both cases. In Philadelphia, they will have a longer process and go through 2 courts, so it wouldn't be fair to compare to misdemeanor. And so they were roughly the same as non-gun cases, but then they are taking much longer. It's 30% slower in 2019 to 2020 than non-gun cases. And this could be because there is less attention or there's more attention. It could be that there's more resources invested and thus it takes longer to dispose of a case, or it could be that there was no change and it's just taking slower because there are fewer people to work on this. And this is just a confidence interval to show that it is outside of what we would expect otherwise. And our next question is actually twofold, and it's about the change in who was handling these cases, the types of attorneys and the workload. We're not going to workload here, but I'm happy to talk about it later. So here we focus on the level of experience. We see that cases are taking longer, and so we're trying to see what else might have changed. And so gun cases are being handled by less experienced attorneys, which we defined as attorneys with less than 2 years experience in the office. And they, but it has had less experienced attorneys. And this is the odds of handling a gun case relatively to a non-gun case. And so it used to be that, yes, so they're being handled by less serious attorneys, though in recent years, it has reversed the trend and it is returning to past levels, and it's essentially the same nowadays. And so for our final question is, we've talked about all the things that changed. And so the next question, as Lee alluded to, is, well, did this have a negative impact in terms of recidivism and public safety at the tail end of the system? And so for gun cases that are not dismissed, the violent felony recidivism increased. And overall, this is true for non-gun cases as well. However, if a dismissed case, gun case is dismissed, the violent felony recidivism decreased. And this is measured 18 months after arrest. Again, this is a time constraint due to the pandemic. So we do see recidivism increase. However, we do not think this is because of declination, dismissals, or withdrawal changes, because again, when you divide it between the two categories, the trend is the reverse. So as a conclusion is the reform efforts have been less impactful than some people have hoped and others have feared in terms of decreasing or increasing public safety. But even when it's unintended, the progressive prosecutions can create changes that affect gun cases which were not targeted by the policies. Though, again, as you saw with the charging rates graph, it's a far smaller scale than the changes that were brought about by the policy shifts that had the intended consequences by the policy. So yeah, that was it. Thank you.
Great. Thank you, Francesca. So to wrap up this quick overview of our research, after 3 more policy evaluation projects, we're going to finish up with a descriptive project about plea bargaining and trying to see what we can learn from having information about initial plea offers made in felony cases. So again, I started by saying part of our goal is by having a team of researchers embedded in a district attorney's office was to open up the black box of prosecutor decision making. Plea bargaining is one of those of the most obscured parts of the system. And so Julia is going to tell us what we can learn from looking at initial plea offers.
All right. Yes. So, whoopsie. Put this over here. As Aurelie has just announced, I'm going to talk a bit about plea bargaining using this novel data set of plea offers at the district attorney's office. So yeah, this project's really exciting because it uses this unique data source and we're able to kind of do some descriptive analyses on plea bargaining. So this is a project that I'm working on with Arruda, Viet, and David Abrams up there. So for a little bit of background, as we all know, all defendants have a constitutional right to a jury trial. But nationally, around 90 to 95% of sentences are secured through pleas. Why are pleas so common? They save resources. For example, they forego the cost of going to trial for both the state and the defendant, and they speed up case resolution. And the received wisdom is defendants will get shorter sentences in exchange for pleading guilty than they would receive by going to trial. Generally, plea bargaining happens behind closed doors, and researchers really don't have access to rejected offers. So yeah, again, this data set's really exciting because it uses novel data on plea offers that we have access to plea offers regardless of what the outcome is. And as a result, our project aims to open the black box, like the so-called black box of plea bargaining. And therefore, kind of our main initial question is, how do these initial offers compare to eventual sentences, and does this differ across different resolution types? We also explore what determines initial offers. So for example, we look at several potential determinants of offers, case characteristics such as offense type and demographics, and also statutory guidelines. And in Pennsylvania, the statutory guidelines are determined by a case's offense gravity score, which reflects how severe the offense is, and the prior record score, which reflects how many priors a defendant has. So for some information about our data set, we have data on initial plea offers for around 26,000 felonies in Philadelphia between 2012 to 2017. This is prior to the Krasner administration. The data quality, people are filling out less offers when Krasner starts, so we kind of subsetted to this time period because we had a more holistic picture. So as I said, offers are recorded regardless of whether or not a plea is accepted, and they provide really valuable information on a prosecutor's first move. One limitation of this data set is that it is limited to cases handled by the initial offer unit, which is also called the pretrial unit for people who are really familiar with Philadelphia. And this unit really handles felony offenses like drug offenses, weapons, property, and robbery cases. Offers on more serious felonies, which are handled by specialized units at the district attorney's office, are not recorded in this database. So we don't really have access to them. So our analysis really focuses on the set of offers that we have access to. And yeah, so offers are maintained in an internal database at the Philadelphia District Attorney's Office, and prosecutors put in a lot of great work to make sure that all the initial offers are recorded so we can study them. Here, yeah, so kind of to show where our data is relative to the case process. So this is a really simplified flow chart of the non-serious felony case process in Philadelphia. After a defendant is arrested, they enter kind of the initial offer phase, and they will get an initial offer from a pretrial, from a prosecutor at the DAO. If that offer is accepted, the case is disposed of. If it's rejected, the case will go to like a pretrial phase where they might get another offer from a different prosecutor. If that offer is then rejected, then the case will go to trial.
And across this entire time, defendants always have the option to take an open plea. An open plea is where the defendants will plead guilty without a pre-negotiated sentence, and the judge will determine the sentence. So the green box, gets initial offer, is where our data is kind of located within the case process. So we have access to all of the initial offers, regardless of what happens to the case later on. And so, yeah, I'm going to go through a couple of our analyses to kind of describe some of our main findings. So this chart here plots the average offer relative to the average sentence across different disposition types. So the gray bars are the mean offer, and then the black bars are the mean sentence. So I think there's two kind of interesting things from this chart. First is that we see across different resolution types, offers are on average higher than sentences. Higher than the eventual sentences. Another thing that is interesting to note is that there is selection into different resolution types. So, for example, offers for cases that ultimately dispose of through open pleas are higher than cases that will resolve through a negotiated plea or a bench trial. Next, we kind of look at how if plea offers differ by race, sex, and offense type. To do this, we analyze what characteristics, like demographics, offense type, are determinants of the initial offer. Ultimately, we find that Black defendants receive offers that are, on average, 1 month longer than non-Black defendants, controlling for all other case observables. And we have a similar finding for male defendants as well. We find that older defendants will receive lower offers than younger defendants. And we also find that offers for weapons and robbery cases are higher than other offenses with similar offense gravity scores and prior record scores. Another thing that we look at is how offers compare to the statutory guidelines. So this chart here kind of essentially plots the percentage of cases that are either above, within, or below guidelines across different resolution types. So in the first column, these are subsetted to all cases that resolve through pretrial negotiated plea. And I forgot to change the labeling here. So pretrial is the Philadelphia kind of lingo for initial offer phase, and then here trial phase is the pretrial phase. So anyway, so for the first column, this is subsetted to cases that all resolve early on with the initial offer. And the red bar shows the percentage of those cases that where the offer is above the aggravated range. The blue bar is the percent of cases where the offer is below the mitigated range. The green bar is the percent of cases that are percent of offers that are within mitigated range, and then the orange part is the percent of offers that are within statutory guidelines. And you can see that if you look at the blue and the green bars across all the resolution type, the majority of offers are either within the mitigated range or below the mitigated range. So that's one interesting point about this graph and about offer prosecutor behavior and providing offers. Another point here is that there's little variation across resolution types. Next, we do a similar thing, but plot across offense gravity score. So on the left hand, so for the x-axis, the higher the offense gravity score, the more severe the case. So cases with an OGS of offense gravity score of 14 are the most severe cases. And we can see that there's more downward deviation in offers for more serious cases. Those blue and green bars kind of expand as you go further and further along the right axis. So people who have more serious cases will tend to get, on average, offers that are lower than statutory guidelines. And we see a kind of similar pattern for the prior record score. So the highest prior record score, 5 repeat felony and repeat violent offender. Those cases have a larger proportion of offers where the offer is below the mitigated range. So some overall takeaways, on average, initial offers are higher than eventual sentences. And that kind of brings up the question, do plea offers play different roles at different points in the case process? So is the initial offer used to kind of sort cases initially, depending on how much evidence is available, so like with the case early on? Is this a negotiation tactic where prosecutors want to start bargaining at a high point and then decrease over time? And then our later offers, i.e. the pretrial phase offers, are those offers that are aimed at incentivizing defendants to resolve the case before a costly trial. So in order to understand this, we need data on later offers, regardless of outcome, and we only have information on initial offers. So overall, we hope this paper will provide like a unique first glance into the plea process, and it would be really great if we could see all offers made. Thank you.
Can you hear me? Yeah, okay, through the mic. All right, so I got already some questions handed over, and that was the Q&A section. We're going to have about 15 minutes for Q&A. If you want to send other questions, you can bring them on. But I'm going to start with summarizing a few questions for Viet. And actually, I know other of Viet's work, so this will be related to some of your other projects. One great question we got is to say, look, supervision time went down with both policies. Isn't this going to increase crime because now people are no longer under supervision? Are they going to commit more crimes? Can you tell us a little bit about the public safety dimension? So you foreshadowed some work that is ongoing about these particular policies and public safety, but perhaps you can answer this question based on other work that you've done.
Yeah, so I've been doing preliminary work looking at just kind of the broader effect of the policies on public safety outcomes. And let me just,
your mic, yeah.
That's better. Yeah, okay. So I've been doing broader work looking at kind of the effect of these policies, because in my past study I just presented, we're just looking at felony cases, but the major things that this policy affects is discharging outcomes, which I don't know if it's Lee, you pointed out, there was huge changes in charging outcomes. And so one of the biggest changes is that there are a lot more cases that were declined for drug possession, kind of lower level theft. And what we see is actually it's quite complicated and quite nuanced. There's these different offenses that were targeted in different ways. You know, some cases receive a lot more diversions, some cases receive a lot more declinations. I think I could just kind of foreshadow, like for drug possession, we saw a substantial increase in declinations, but really no trade-offs in public safety. The similar rearrest rates, similar reconviction rates. But for other offenses, such as, kind of misdemeanor gun possessions, which are much more complicated, we see an increase in diversion, but there are some public safety trade-offs. So I think this question, I think, requires a lot more detail. When we can't just really just say, public safety increased or decreased, but it's really just taking a deep look at each of these offenses and seeing actually what happened, and what's, the best things. And maybe in some cases, diversion is the optimal outcome. In other cases, maybe diversion is not the right tool. And maybe it's just changing those supervision conditions and whatnot.
Great, thank you. So now I'm going to turn to a question for Lindsey, which is, there's a few questions I'm going to try to summarize a little bit. One is about variation across different types of witnesses. So for example, have you looked at witnesses for different kinds of crimes or victims for different kinds of crimes? And can you speak a little bit to differences and how likely they are to not show up to court? And then a related question, which I think will speak a little bit to some of the interviews that you've been able to do. Can you speak a little bit about the relationship between different actors, so prosecutors and police, victim coordinators and victims, and how this influences people's likelihoods to show up in court? And then lastly, did you see any changes before or after DA Krasner was elected in failures to appear?
Yeah, thanks. So the first question, failures to appear by crime type. I wish I had the clicker. We do look at this. And so we see victims are more likely to fail to appear for domestic violence cases. It's like over 70% of domestic violence cases have a victim FTA. The trends look really similar for other types of civilian witnesses. They're more likely to FTA for DV and violent crimes. Police officers, it's interesting. Go here. Yeah. So here's victim by crime type. There's other witnesses by crime type. And then we find that police officers, they're feeling to appear, I don't have the descriptive plot, but they're feeling to appear the most often for drug and DUI cases. This is really interesting because these are the cases where the police officer is like the linchpin of the case. There's usually not a victim or someone else you could call. And so the police officers are having a really big impact on the drug and DUI cases. The second question was about like relationships between people and how that might influence FTAs. Yeah. If whoever asked this has like a more pointed thing they want me to talk about, please speak up. But we did do a lot of interviews. So what happens is there are victim witness coordinators who do a lot of work trying to contact people, maintain relationships with people. But really, who is trying to get people to show up is the prosecutors, especially in the misdemeanor courts. So the prosecutor will call the victim or witness usually 3 days before court. If they can't contact them, they'll leave a voicemail. And I've sat and watched them do this many times. And for those of you who are prosecutors, maybe you've done this. There's sometimes like a lot of talking and convincing and coordination, even like trying to find them a Lyft ride so they can come to court. The prosecutors are also sending the subpoenas to the police officers. And so we've heard from prosecutors how important it is for them to build a good relationship with officers over time, so they'll still want to come to court. So those are a few things we've heard about that. What was the last question?
Whether there were changes over time in failures to appear.
So we don't really see changes over time in failures to appear, but it's a little bit difficult. One big question the office has asked us is, did officer failures to appear change when Krasner took office? Because maybe there's some friction now between, the DA and the police office. And this is actually really hard for us to look at because we only have the subpoena information starting in 2018 when Krasner took office. So just in terms of raw numbers, it's pretty flat, but we can't look at like the conditional FTA rate before and after Krasner.
Great. So I have a few more questions, but if you want to send more cards, you can bring them up directly to you. Feel free to raise your hand as well, and I will repeat questions that come up. So the next question is for Julia and asks, how did you get the plea bargaining data? And I do want to say tomorrow there's going to be a panel about, what it means for researchers to work with prosecutors' offices. And I'm sure a lot of these questions will come up. But, already if you want to say a little bit about both this data and the other data efforts you made to try to fill in some of the holes we had thanks to this partnership that we had.
Oh, okay. So, sorry, this is really loud. So as part of our partnership with the DA's office, we have access to all of the data sets available there. It was the plea bargaining data is one of the tables there. And I think I will defer to Marielle if you are interested in working with the data. The DA's crowd's kind of sitting up there. Yes, Michaela. If you're interested in working with the data, you should definitely reach out to them. To see if you can get access to it. So one thing that we also do, as Aurelie was mentioning, we want to figure out how holistic and complete these data were. So we did run a little random survey of around 300 case files that we thought would have offers in our data set, but were missing. And we found that most of them didn't receive offers, and we were able to kind of back collect around 25% of those. So overall, it's a great data set, and the true missing rate is very, very low, around 5% of offers. So it's a great data set to work with. And yeah, definitely reach out to the district attorney's office, Data Lab, if you're interested in working with it.
And I'm going to add a little bit to this. So I think, my understanding from having tried to work with various prosecutors' offices is there's a lot of variation in what is collected and what is systematically collected. So perhaps you work in an office where a lot of things happen more informally. One of the reasons why we focus on so even within offices, there are variations. One of the reasons why we just look at felonies is actually the one place where initial plea offers were systematically reported was for non-specially assigned felony cases. And so, there is kind of, this question of what do plea offers that are rejected, what do they look like? That's an important question where basically we had no information about this. And so took the opportunity to look where we had information. But again, Julia finished saying, look, we just know the initial offer. And obviously we would like to know how offers evolve over time to be able to answer important questions. So, this is both, we had this great opportunity to look at systematically one point in the system, but of course there's variation. As case management systems develop, we hope that we'll be able to look at other points in the process as well and other kinds of cases. So I think there's a few more questions. In the meantime, I'm going to throw another very big picture question to Lindsey. which is, and I think this applies to various projects, so if others want to chime in as well. So the question is there any variation across prosecutors in their failure to appear rate, and what can we learn about good practices? So even though this is a question about failures to appear, I feel like this applies to other dimensions of prosecutor decision making as well. What can we learn about particular prosecutor decision making that could help inform broader policy?
Yeah, I guess I'll plug a forthcoming project with Aurelie on this. We're looking at what do prosecutors do, and do prosecutors vary in different types of skills that they have. And one thing that I'm really interested in is prosecutors' kind of case management skill, because really one of the main things that they're doing is coordinating human beings, which I didn't realize prosecutors did so much of before I started working in the system. So short answer is I do see variation in that, both in the data and also in shadowing folks. Prosecutors have very different ways that they manage their cases and talk to people on the phone. Some prosecutors take a really harsh approach where they're like, look, you could be thrown in jail if you don't come to court. Like, this is a court order, you have to come. Versus other folks who are, they let the victim tell them their story for a while and then try to, talk them into wanting to come to court to tell their story. So yes, we do see variation in that, and we're hoping to talk more about that in future work.
I like that also. I think like variation in prosecutors is also a function of what courtrooms they're positioned in. Like, your judge is going to influence a lot of what you're doing. So I think the challenge of research is trying to disentangle what part of that variation is due to the prosecutor versus what other judges or defense attorneys that they deal with on a day-to-day basis.
Great. So I'm going to finish with what appeared to be a combination of questions and policy recommendations. So there were some questions that were a little bit more policy oriented, just going to put out to you, a little bit more research oriented for finishing with policy, especially Viet for your project. So related to asking, how can you disentangle short run versus long run effects of the policies versus two policies were subsequently adopted? So I think this is a good question. If you want to speak to it, go ahead, and then I'll.
So I think what we try to do is we try to break down our estimates based on different time periods where we think things will be implemented differently. So, the one that I just presented, we broke down the estimates based on when there were different rules. But also in talking to people in the courtrooms, we can try to understand like what is actually practically happening. Are there changes in turnover in staff? And we could also break down estimates based on what we think is actually happening physically in those courtrooms that might change how cases are disposed of. So we use a combination of what we see in the courtrooms, what we do when we're talking to different prosecutors, plus what those higher level legal things are publicly announced. And we use those two things together to try to break down how these policies are actually being implemented.
Great, thank you. And so I'm going to finish with two more policy recommendations, which is really great. So one question was around policies, just recognizing here we look at what happens when police officers don't show up to court. But one question is, why aren't there more policies to, take action when a police officer doesn't show up to court, kind of saying, look, if I don't show up to my job 5 times, chances are I'll be fired. And so why aren't there these kinds of policies that exist in other places of the criminal justice? For example, police officer doesn't show up. So first, I do want to say, in the interest of time, we didn't go into the more nuanced conversation. Like, there are some reasons, like maybe a police officer doesn't care and doesn't show up, but there are also some logistical reasons why police officers don't show up to court. As an example, perhaps they're asked to show up in 2 places at one time, and they can't split themselves up, so they literally cannot be at 2 places at the same time. So I think there are more systematic organizational reasons why this may be happening, and this is just one illustration. I do want to say that, one of the goals of this research, again, I think for anybody who's worked in a courtroom, the results that Lindsey in particular presented are not surprising. But what we're hoping is to turn your individual experience into just bringing numbers at a courtroom or a jurisdiction level to help inform policy. So hopefully now that we've showed, look, this is not just your experience, this exists across courtrooms, it exists over different periods of times and things like that, then it means that we can start to think about solutions. I don't know what exactly the solution will be, and it'll probably be complicated and complex, but we hope that this descriptive work will help inform this. So then another good example of what reads both as a question and a policy recommendation is asking, Can we say anything about people who refuse pleas and are later exonerated to better understand how these factors correlate with one another and to get some insight into coercive pleas? So this seems like a really great question. And again, we hope that this is just the first step in the work that we and others are doing, and that using this kind of data, which wasn't available before, will enable both researchers and practitioners to make progress on these important questions. So thank you, everyone, for your great questions, and thanks to the panel for presenting this research.